The state is seeking a protective order to keep certain people from being witnesses for Sarah Boone. But before that, we have to start with the state's memorandum regarding defendant statements to Deputy Kayla Rodriguez and Detective Kopsel and Lowen on February 24th, 2020. Comes now the state of Florida by and through the undersigned assistant state attorney and states alleges following. Deputy Kayla Rodriguez, in response to a 911 call made by the defendant shortly before 1 p.m. on February 24, 2020, responded to the defendant's residence. Deputy Rodriguez activated her body-worn camera while still en route to the defendant's residence. All interactions with the defendant were recorded. There are 3 recordings, one beginning at 1:08 p.m. and lasts 13 minutes and 32 seconds, the next approximately at 1:22 p.m. and lasts 4 minutes and 56 seconds. The final one starts at 1:30 p.m. and lasts 5 minutes and 30 seconds. At no time was the defendant in anything that resembles custody for Miranda purposes. The Ramirez cases outlines the famous 4-factor test, a manner in which the police summon the suspect for questioning, the purpose, place, and manner of the interrogation, the extent to which the subject is confronted with evidence of his or her guilt, whether the subject is informed that he or she is free to leave the place of questioning. While Deputy Rodriguez would not let the defendant enter the crime scene, the defendant's home, to retrieve a soda or cigarettes, the defendant was not in custody. That's a nice little cheeky comment there. It's factual, but to me it sounds a little cheeky. The defendant was a first responder trying to gather preliminary information about what might have happened. The defendant was spoken to on her porch and sidewalk area just outside of her home. She was not confronted with any evidence because at that time there was nothing to confront her with. The defendant was informed that she was not free to leave the area due to the investigation, but the restraint on her freedom of movement never resembled custodial arrest. Just under 4 hours later, she was interviewed by Detectives Kopsel and Lowen inside an unmarked car on the scene. Although under both Ramirez and Rincon, this is not custody for purposes of Miranda, she was given her Miranda warnings. For the reasons outlined in the state's response to the defendant's motion to suppress statements at OCSO, the Miranda warnings were not defective, and her waiver of her Miranda rights was voluntary, and her statement was voluntary. Any motion to suppress on these statements would not be granted. Now let's get into the state's request for protective order. Comes now the state of Florida by and through the undersigned assistant state attorney and state alleges as follows. The defendant in her 3rd amended witness list has listed the following people as witnesses, and people is in quotes. I'm not sure exactly why. I think it's because it's positions more than people. Custodian of Records, Orange County Office of the State Attorney. Domestic Violence Supervisor for the Office of the State Attorney, 9th Judicial Circuit, Orange County. Victim Advocate Supervisor for the Office of the State Attorney, 9th Judicial Circuit, Orange County. Misdemeanor Supervisor for the Office of the State Attorney, 9th Judicial Circuit, Orange County. The state requests a protective order under the Florida Rule of Criminal Procedure because anything these witnesses could say about the defendant and the decedent would be protected by work product privilege. Florida Rule of Criminal Procedure 3.220G1. If the defendant wants public records from the state attorney's office, she should do whatever everyone else has. She should do whatever everyone else has to do. File a public records request. Subjecting prosecutors and their staff to this type of discovery of their investigations would require the disclosure of work product and seriously impede criminal prosecutions. We believe the trial court was right the first time in denying the pretrial defense efforts to subpoena the 2 state attorneys and inquire into oral communications, sworn or otherwise, between them and a state witness. The oral and unrecorded statements of witnesses to a state attorney are privileged as work product and not subject to discovery as for Olson v. State. Previous one was Egan v. Demanio, and State v. Robin. Opinion work product involves a lawyer's impressions, conclusions, opinion, and theories of her client's case. Opinion work product is an absolute or near absolute privilege. It's Horning, Keaton versus State. Fact work product concerns what the attorney did and what she learned in her role as attorney. As the name suggests, fact work product is factual information which pertains to his client's case prepared or gathered in connection herewith. And this is citing Raven. The fact work product is discoverable only if the parties seeking this work product show the court the need for this fact work product to prepare a party's case, and 2, that without the unique undue hardship, the party is unable to obtain a substantial equivalent of this fact work product by other means. Thus, need and hardship elements must be alleged in the motion to compel and establish to the court's satisfaction at an adversarial hearing. The state is at a loss for what non-privileged testimony any of the people in quotes again, listed could provide in this case. Therefore, the state is requesting the court to enter a protective order to prevent any employee of the state attorney's office from being a witness in this case. So, basically, they were trying to pull in these people, well, these officers, these officials, to have them on the witness list, and the state's like, no, you can get a hold of their results, but you can't, have these individuals themselves. You can't have them ask them their opinions and bring them up as witnesses. At least that's what the state's trying to do, and it does seem like they have given a good long list of reasons why these people should not be able to be witnesses. But it was so interesting. I was just scrolling through, checking Sarah Boone updates, and there was, the witness stuff, and then there's this protective order list, and I'm like, my first thought, I'm gonna be honest with Sarah Boone, my first thought is maybe she had personally tried to contact a witness, but I guess that's not the case, right? So what do you think about this here? I think it makes sense, right? I think it makes sense that you can't just call in random. Number one, imagine if every criminal case that involved these offices pulled all of these same people in. They could never get their work done. Number one, that just doesn't seem feasible. Number two, what could they possibly want from them that they can only get directly from them? Are they wanting to use them almost like a pseudo expert and try to play off, well, what would a battered spouse do in this scenario? Because I don't think that's allowed. I use them as a pseudo witness, expert testimony. I don't know. And then of course we had this here where, again, they're pulling this Miranda stuff where the argument here is Miranda wasn't needed. Miranda was not needed, but Miranda was still given. And this is coupled with the last time where they went through in detail why the Miranda was sufficient given during the interrogation. So I asked in my one video, is the lawyer doing what Sarah Boone asked, right? Because I would think that the lawyer would know this wouldn't work, right? And I would think the lawyer would also know that this isn't going to work. You know what I mean? I would think this wouldn't be I would think that this isn't a new idea that a lawyer's had, right? There's obviously case law here, right? But the lawyer put this out. And my question is, was this a Sarah Boone idea? And he did it. And instead of telling Sarah Boone no, was it easier for him to submit the document and then have the state tell her no? And that way they're still on good terms. That's what I'm wondering. I'm wondering if he's doing a lot of this just to placate her so they can keep moving the case forward in whatever fashion that's going to be.